The JMF Advisors Show is a podcast for business owners, C-suite executives, and entrepreneurs who are looking to build, grow, or even exit a business.
We bring in some of our best financial advisors to interview experts on business best practices, hot topics, and sprinkle in some tax and accounting help.
If you're a business owner, startup founder, CFO, or just starting your side hustle, this podcast is for you.
Hello, everyone. I'm Orman Wilson. I am a CPA with JamisonMoneyFarmer, and I specialize in estate and trust work. And today, my guest is Emilee Scheeff. She is an attorney with Rosen, Harwood. She also specializes in estate and trust work. We want to talk about what to do when a loved one dies. It's a very traumatic, stressful time in the survivor's life. We don't want you to wait till the last minute during this stressful time to try to take care of business. So we actually want to begin our presentation with stuff that you should do before someone actually dies. Maybe they've become ill. Maybe you know the end is near, and it's just stuff that would help make your life easier once they are gone. So, Emilee.
Yes.
What would you suggest?
So one of the first things I would tell them to try to find would be to try to locate the individual's will, hoping that they have one. A lot of times people go do a will 5 years ago or something, and then they put it in a really safe place, never to be found again. And their children or spouse may not actually know where it is, and then you can avoid, hopefully, that scavenger hunt after they're gone. If they can tell you who their attorney is, that's also another thing you could find out, because a lot of times the attorneys that do their will at least keep a copy of it, if not a second original. My policy is I do 2 originals for a client. They take one home, put it in a real safe place. I keep one in our files, but they have strict instructions that if they ever update or change anything, that they need to come back to me, because we got to get rid of their old one. Or if they use somebody else, just tell me and I'll get rid of your old one. So that's kind of the first thing I usually tell them to find, no matter what. They a lot of times have like a power of attorney that you may be needing to use also while they're sick, because somebody's got to pay the mortgage during that time frame. So those are just find the important documents mainly. I think yesterday we were talking about maybe also if they have a prepaid funeral. You know, I wouldn't know if my parents had a prepaid funeral because if you've got one, you don't want to have to spend all that extra money.
Yeah, and from a personal standpoint, when my dad passed, I would have bet the farm that he had prepaid his funeral. And come to find out, you know, my mother had all the burial policies. Mm-hmm. I went with her to the funeral home. We met with the funeral director. She gave him all the policies. And I asked her, I said, now, yours is not prepaid either. She said, no, but I've got all the policies. She keeps them in a safe place at her house. Every time I go visit her, she reminds me where all the important documents are. And so it's good to know. I hope I don't need to find them anytime soon, right, but at least I know where her important documents are.
And as part of this, I even had a conversation with my parents last night about where do they keep their important documents. It turns out it's multiple places around the house, which is going to be great if I ever have to do that. So that's something beforehand. If they just get a diagnosis or something, they could try to locate all those and put them in one place. While you may not need them at this time, it would be helpful to just have them in one place where you can go to that filing cabinet or that safe and locate it at that point.
Yeah. And speaking of the funeral, you need to know, do they want a funeral? Do they want a celebration of life? Do they actually want to be buried? Mm-hmm. Would they rather be cremated? All these arrangements, if you could get them in writing from them, at least you know what their intentions were.
Yes. I've had some clients that were very passionate about the fact that they didn't want to be buried. They actually want to be cremated. You know, telling your attorney's great, but I'm probably not going to be there when that happens. So you need to make sure and tell your kids or your spouse. And that would be part of that conversation you could have if someone is sick.
Yeah. And I've been doing this for over 20 years. A lot of times a person will die and no one even knows they had insurance, life insurance.
Right.
You need to find out, do you have life insurance? If so, who with? How many policies do you have? Mm-hmm. And I would hate to guess how many people die. Their descendants didn't know they had life insurance and the proceeds never go claimed.
I've had a couple of states that I've even had to reopen because 3 years later they get something from a life insurance company and turns out there was actually a policy. Because that's not something like a bank account or something where you're receiving a statement each month in the mail. So there is really no way for those loved ones to know unless you've either told them or keep your policy documents with all of your other important documents.
Yeah. And I know that later you're going to talk about probate assets and non-probate assets, but it would also be helpful to know, do you have an IRA? Do you have a 401k? Any other type of annuity? Just get a list of all their assets together in that safe place so they're easy to find, so that whoever the executor or personal representative might be will know where to look, what to look for.
I have had several clients also CDs. You know, older clients a lot of times will keep multiple different CDs in multiple different places. So I've had to send the executors or personal representatives on a scavenger hunt, basically go to each bank because there was not a list like we're talking about. And they found, 10 or 15 different CDs just because that's what those clients thought were safe investments. And, I hope they found them all. But that's the best we could do is they went to every bank around there looking, kept checking the mail to make sure that no statements or 1099s came in. But it would have been very helpful had there been a list of those CDs and all their assets.
Yeah. And one thing, estate planning is very important. No one likes to pay taxes.
Right.
If your estate, thankfully, the exemption is $12,060,000 this year. I scooted right in under that.
I know.
So thank you for the index. But anyway, if your loved one could possibly be over the exemption and owe estate tax, one thing you could suggest is gifting. Right now, you can gift $16,000 to anybody, anywhere, with no tax consequence to the donor or the donee. Mm-hmm. I have seen it before where a person was close to the exemption amount, wrote checks to, 25 different people. Mm-hmm. Half of them had not cashed the checks before the person died. And so those checks were brought back into the estate and wound up being taxable. So it's just something to consider.
Right. And if somebody's giving you a check at that point, they want you to go to the bank. They don't see that as greedy. They want you to hurry to the bank to deposit that.
Right.
It's not that they will look at you as greedy and only wanting their money. That is a strategic plan to not have to pay taxes potentially on that. And you need to rush on down to the bank.
Exactly. Okay. We've kind of touched base on things to do before the loved one dies. So let's assume the loved one is now deceased. So what should the decedents do?
Well, the first thing they're going to be searching for after the funeral and all of that is trying to find their will. Hopefully they've had the conversation beforehand to locate the will or at least know who their attorney is and know where they keep their will. After they find that and have their death certificates, which they will order through the funeral home. And I always tell people order several copies, not just 2 or 3. We're talking like 10, 15, because you will need several of those. And then you need to schedule a meeting with an attorney that specializes in probate, and also the CPA. Ideally, I always like to meet with the client and the CPA at the same time, because the CPA needs a lot of the same information that I do, and it makes the process easier and actually cheaper because we're getting the same information at one time and we're not having to go back and forth. So having that meeting is very helpful. And when you come to that meeting, try to come prepared. And when I say prepared, you're never going to truly be prepared probably for what's going to happen in that meeting, but bringing the will, the death certificates, and then also going ahead and collecting names, addresses, and phone numbers for surviving spouse and all the kids. The CPA will end up needing that information, and then the attorney also needs that information to include it in the petition to start the probate process. So, typically when they come in, the first thing we talk about is what does the actual probate process looks like. Everybody has this fear that it's this horrible process, it's going to take forever. And I always start by explaining to people that the process in Alabama is not that bad if your family members get along. That's the caveat. I can't control that. They can't control that. And the ones that you hear the horror stories from, it's all the family dynamic. It's not actually the legal aspect of it that's so terrible. So, brief overview of the probate process. The first thing we will be doing when someone comes in order to probate the will and go through that process, is filing a petition to have the estate open and the will admitted to probate. That goes over. If everyone, all of the children and everything are in agreement with that, they can sign a waiver so we don't actually have to have a hearing in front of the probate judge. If they don't all sign the waivers, or if we have some minors, then at that point we will have a hearing, and the judge, unless there's something wrong with the will admit it to probate. At that point, there is a 6-month window that it has to stay open. That is to allow any creditors of the decedent to, essentially raise their hand and say, hey, I'm owed money, you got to pay me off in this process. Once it's opened, the executor or personal representative can go ahead and start liquidating the assets, cleaning everything out, which is usually quite a process. But they don't have to wait until the end of that 6 months to start that process. So it stays open for a minimum of 6 months to allow the creditors to essentially raise their hand. And then once that time frame ends is when we start actually dispersing cash and whatnot to the beneficiaries.
Okay, let me interject.
Yes.
You've mentioned the probate process.
Yes.
Okay. Explain the difference between probate assets and non-probate.
Okay. So this is also part of, that initial meeting, is we'll be talking about what assets are you actually going to be dealing with as part of the probate. So there are 2 different ways that your assets pass when you are gone. So there are things such as bank accounts, IRAs, life insurance policies, and on all those types of assets, you can put a beneficiary or a payable on death. What that means is that is a contract with that bank and that institution, and you will just have to bring them a death certificate and sign their claim forms that they will give you. At that point, that asset passes pursuant to that beneficiary designation, no matter what your will says. So it is outside of probate. It is gone. A lot of the times, the assets that we end up dealing with in probate are real property, cars, the things in your house. And then any of those accounts that are solely in the decedent's name with no beneficiary on it. So there are 2 lanes on the highway, and we hope that they're going in the same direction, essentially. A lot of times that's very difficult for the loved ones to understand, because while the will may say that everybody gets a third, if they only had one person as the beneficiary on the life insurance policy, I can't do anything about that as part of the probate process. And that is not the personal representative stealing from them. That is just how that asset passes, because it goes outside of probate. So I always try to explain that to clients in that initial meeting. And it's very important for whoever is serving as the personal representative to be, open and try to communicate with all the beneficiaries so that they know what's going on. Because it does take a little while. And when it takes a little while and they don't know what's going on, they have a tendency to think that, so-and-so stealing from me or is taking everything for themselves. So that open communication is very helpful. So once you kind of wait out that 6-month time frame and start dispersing the assets, if everyone is in agreement with how everything's been handled, they can sign off on the final settlement, and we essentially send that over to the court and get an order back. That's best case scenario. Doesn't always happen, but it typically, if there's a good family dynamic and there's been a lot of open communication, you're a lot more likely to get that based on what I've seen over my years of practice.
Yeah.
So that's kind of the general overview of what you're going to be looking at from a legal standpoint. There's also the accounting side of it, which is why it's important for the CPA and the attorney to work together. I need to send them to make sure they see their accountant, because there are returns that have to be filed for that deceased individual and for the estate potentially.
Yeah, and Emily mentioned it's great if the initial meeting can be with the attorney and the CPA. Cuts down on cost. There's less communication error if we're both receiving the same list of assets. Beneficiaries, names, addresses, social security numbers, phone numbers, that all comes into play. The person will be required to file a final 1040. You always hear only 2 things certain in life: death and taxes. Right. Uncle Sam wants that final 1040, and we have to split out the income before death, after death. We would have to do an initial 1041, a trust return for the estate. And there is a caveat in that. There's a $600 filing requirement. As long as the estate doesn't earn $600 gross income, there's no filing requirement.
Right.
We will need to check that every year until the estate is actually closed. There's also the possibility that we would need to do an estate return, a Form 706. Normally, if you don't meet the filing requirement, which I mentioned earlier, is $12,060,000 in 22, you might still want to file an estate return if there's a surviving spouse. And I'll tell you why. Whatever unused exemption the decedent has can be transferred to the surviving spouse. So we call that a portability return. And that just increases the surviving spouse's chance of not owing estate tax when he or she dies. Now, at Jamison Money Farmer, we like to sit down with the surviving spouse, explain to him or her what's going on, what exactly is a portability return, how it works. And if he or she says, no, I don't think I want to do that, we go, hey, that's fine. That's your prerogative. here's a statement that we want you to sign that says, Orman Wilson has explained to me the portability, and I decided not to do it. We want them to sign it and date it. And I had one client say, well, why should I sign this and date it? And I said, well, if you hit the lottery,
or the exemption goes down.
And the exemption goes down, which it is going down December 31st of 2025, and your estate owes money, I don't want your children coming after me because they have to pay tax now. And she understood then.
Right.
And on a side note, she told me, I don't want to do it. I said, well, that's fine. So she signed it. A couple of weeks later, she called and said, I think I want to do the portability return. And I said, why? And she said, I'm going to North Carolina and I'm going to buy a Powerball ticket. And I said, well, I tell
She
you
had
what.
high hopes.
Yes. I said, I tell you what, I love your optimism, but let's wait till after the drawing. And if you need to do it, we'll do it then. So we both had a big chuckle. But unfortunately, she did not win the Powerball.
She'd been a great client if she did.
Yes. But, you know, we mentioned life insurance policies. If we have to do an estate return, we will prepare a letter on behalf of the executor, and it's called a Form 712 request. Now, the insurance companies won't tell us anything, but the personal representative, the executor, they can actually send a letter to each insurance company. Of course, they'll need to list the decedent, the Social Security number, and the policy number. That's why it is so important that we have this list of insurance policies. Once the insurance company gets it and verifies that it was indeed a death, then they send information that will tell us how much the proceeds are and who the beneficiary is. Now, the good news is the insurance proceeds are not taxable to the beneficiary,
Right.
so they don't have to worry about that.
They've just got to fill out their forms.
Yes,
and
they just have to fill out the forms.
get that submitted so that they can actually get the money. That's why that list is so important, is because you don't get a statement, you know,
Right.
each year or whatnot from the insurance company. So we may find out that there's a policy 3 years later that we're looking for. So keeping that list of your assets, you know, while you're alive in a safe place where your kids or whatnot can find it's very important. I also imagine that y'all are probably filing a lot of portability returns right now because of some of the uncertainty on what the exemption is going to be
We are.
in the future. And I've encouraged numerous clients, while it's $12 million now, it's set to go down, and you know, who knows what
Yeah.
Congress is actually going to do with it.
Well, Congress says it on January 1st of 2026, it will go back to the 5 million and be indexed, you know, for inflation up till now. I mean, how much is that going to be? 5.7, 5.9, 6 million, who knows? I mean, that's still a lot of money.
Right.
But that a lot of people do exceed that amount. And so it would be important for them to take advantage of it now.
Right, because if a loved one passes away with a $12 million exemption, can transfer that over to them.
Oh, yeah.
Then, you know, they can save a lot on estate taxes at that point.
And I'm not knocking Congress, but who knows? They could decide, let's just go back to $1 million, and anything over $1 million we're going to tax.
Right. And in addition to the federal returns,
Yes.
you get to deal with all these 50 states too.
We have several states that actually require an estate return or what they call an inheritance return. Thankfully, Alabama is not one of them any longer. Now, they were the first few years I was doing this. We had to do a federal estate return and an Alabama estate return. I don't remember exactly when it ceased, but it's been a few years since I've had to do an Alabama return. Now, the states have their different limits.
Right.
I think it's Ohio. I'm not sure. Don't hold me to it. I think their limit's like $600,000. It's something pretty low.
Mm-hmm.
And
So you need to move from
right,
Ohio.
yeah. Florida has some kind of inheritance tax return.
I think North Carolina does potentially. I've got an estate there that I think their accountant's working on filing one there also. But so there's really a set of returns that your CPA is going to have to sit down and go through to see if you need to file them. And that's why it's also beneficial to have the attorney kind of involved at least in some of that communication, because I don't need to close out an estate before y'all have had time to file all the returns.
Right.
Because the time frame to file the portability return is longer than the creditor claims period, so I don't need to close out at 6 months if y'all are still working on.
Right. And the good thing about a portability return, or what we call a DeSuey return, you're supposed to file an estate return 9 months after the date of death. Okay. It's a pretty complicated return. You get an automatic 6-month extension, no questions asked, because it's basically a snapshot of what is this person worth on the date of his or her death. All right. Let's say you're not required to file. Then you discover something like there's insurance policies that you were unaware of, maybe an IRA, whatever the case might be. It was 3 years from the date of death. You could file a late election to get the portability. Well, Congress recently extended it to 5 years.
Right.
So there is some relief in case you didn't meet the 15-month deadline to start with.
But that's, something you always want to try to look at initially, because there's a lot of homework that goes along with filing one of those returns. So in addition kind of to what the attorney's going to be doing from a legal standpoint and what the accountant's going to be doing, there's just some kind of housekeeping things that I always tell clients, and I know y'all tell your clients also, that they want to do, such as contacting Social Security. They typically figure it out very quickly from what I have found, and they want to pull back that last payment a lot of times. So people don't need to spend that money because they may be coming back for that one. Housekeeping things such as just canceling voter registration. Otherwise, they're on the list and will be there for years and years to come. Canceling credit cards. I've had once or twice where, there may have been a child or grandchild who came in, got grandma's credit cards, and went on a shopping spree the week after grandma passed. And that always creates a lot of fun. So just the first step being securing that wallet, or the purse, to make sure those things don't disappear. And then second step, going through and trying to cancel them all.
Yeah. And one thing I'd recommend, there's a 6-month waiting period for a creditor to come forward. If you know the decedent owes a bill, just go ahead and pay it. It just speeds up the process. And
the only thing I'll caveat that with is if you know that they're going to be short. If we're going to be close to being an insolvent estate, then those at that time, we send them the notification, they file their claim, and then we have to sort it all out. I don't have too many of those estates, but I have had a couple where there was the equity in the house was going to be close to covering all the credit card bills and the funeral, and all those things, because there wasn't a prepaid funeral policy. So that's the only time, I tell clients, if you think we're going to be close, hold off on paying them till we know what the full lay of the land actually is.
Yeah, now that you mention it, I've only dealt with one insolvent estate.
I think I've had, a handful that were truly insolvent, and a lot of times we were only opening that up because there's a preference on who gets paid. So the first thing that gets paid back is the funeral. So if a family member paid $10,000-$15,000 for a funeral, they can get reimbursed first, and then the attorney's fees, and then a lot of times your credit cards and all your other general unsecured creditors kind of land in that boat all together, and they're fighting kind of for what's left over. So a lot of times I've had a couple where we've opened solely to get the family reimbursed for the funeral, with the equity in the house or something like that.
And whether you think you'll need an EIN or not, I suggest to go ahead. The attorney can get it for you. I can get it for you. We can apply online. It's a speedier process to get it for the estate, because as your accountant, I would recommend opening an estate checking account. Any income that comes in after the decedent has passed, put it in that checking account. Any expenses that of the estate, pay it from that estate checking account. It's a neat, it keeps the records neater and easier
And
to
it's
reconcile.
Much easier on the personal representative at the end when there's that one beneficiary going, well, where did all mom or dad's money go? Well, here's everything we put in the account, and here's all the expenses that came out, and here's what's left. And that's what we're splitting. We sold mom's car. Here's the deposit. We sold all the stuff in the house. Here's the deposit. It makes it very clean and easy to explain. If we were, putting the cash in a drawer, that makes it a lot more complicated.
And I have seen the case where the personal representative actually needed to pay some bills on behalf of the estate before the estate checking account was open.
Right.
No problem. Just keep records of what you paid, who you paid, what it was for, and then you can get reimbursed for your out-of-pocket expenses.
Yes. And any of those expenses that you paid for, like their last sickness or whatnot, has a preference also over their general unsecured creditors. So that's always something you want to consult with your attorney before you do it also. Don't just write yourself a check. Make sure you talk to your attorney or your accountant, because they're going to make sure that you have the correct documentation to go with that, so that it's not a problem when the one problem child starts asking questions.
And speaking of a problem child, let's say you're lucky to be named executor of an estate. You would be surprised how soon you start getting contacted. When will I get my money?
I've had them not even leave the hospital before after mom or dad's death.
Well, the problem with that is, let's say you go ahead and distribute the money, and then it winds up being taxable. Then you have to contact the old beneficiary and say, hey, you need to send some money back to me to help pay the taxes.
And it may or may not have already been spent.
That's not a position you want to be in, because I will tell you this, as executor, you will pay the tax whether you get reimbursed for any of it or not. So you don't want to be in that situation for sure.
And that is why it is so imperative that your attorney and your CPA communicate, and that you communicate with both of them. Because I've had some that, I don't want to say they go rogue, but they think they can handle it all and don't necessarily tell you. A lot of those have typically worked out because there hasn't been a taxable situation or everybody was on the same page, but it can happen, and it would be bad if that did happen.
Now, Emily and I do this for a living. It's kind of second nature to us. We could sit here for days and tell you things to do, what not to do, when you have a loved one pass. We don't have that much time.
Right.
So, I am happy to report there is a memorandum on www.jmf.com, and it's called What to Do When a Family Member Dies or a Loved One Dies. You can go on there. It's 27 different steps, and that by no means is all inclusive, but it does give you several good ideas and steps to follow that
Right.
just helps you during this stressful time of
Right.
your life.
Yep.
Can you think of anything else? I'm sure on the way back to work, we'll go, oh man, we didn't mention this.
I mean, I think we've pretty much covered the highlights. There's always something unique. So, communicating with your attorney and your CPA, I would say, is at the top of that list.
Yeah. Okay. Well, thank you for joining me
You're
on this
welcome.
podcast. I appreciate the help.
You're welcome.
If you would like us to help your business or would like to suggest additional podcast topics, simply send an email to info@jmf.com.
And don't forget to subscribe to our podcast on YouTube and your favorite audio podcast apps.